makes no difference how old I am, or what color I am, or what church I belong to, if any. The question is very simple. The question is, I did not get a fair trial.
Congress shall make no law respecting an establishment of religion.
No soldier shall in time of peace be quartered in any house.
No person shall be deprived of life, liberty, or property without due process of law.
The words of the Bill of Rights were written deliberately, written to be understood, but they have not always been understood in the same way. One of America's great legal minds, Oliver Wendell Holmes, wrote,
"A word is not a crystal, transparent and unchanging. It may vary greatly in content, according to the circumstances and the time in which it is used."
The next case on the docket is the case of State of Florida Plaintiff versus Clarence Earl Gideon, defendant. What says the state? Are you ready to go to trial in this case?
State is ready, Your Honor.
What says the defendant? Are you ready to go to trial?
Your Honor, I'm not ready for trial.
Why aren't you ready?
Because I do not have a lawyer.
Why don't you have a lawyer? Did you not know that this case was set for trial today?
Yes, sir, I know the case was set for trial today.
But if you knew your case was set for trial today, why did you not secure counsel and be prepared to go to trial?
Because I'm without funds to hire an attorney. Your Honor, I'm going to ask this court to appoint me counsel to represent me in this trial.
Mr. Gideon, I'm sorry, but this court cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint a lawyer to represent a defendant is in a capital case. That is a case involving the death penalty.
Well, the United States Supreme Court says I'm entitled to counsel.
Ms. East, would you let the record show that this defendant has requested the court to appoint counsel and that this request has been denied? Let's have your seat in the courtroom, Mr. Gideon.
In 1961, 170 years after the ratification of the Bill of Rights, Clarence Earl Gideon requested that the state of Florida appoint a lawyer to defend him in court. Ex-convict, wanderer, a former gambler, the devoted father of 3 children, and a man with a deep sense of his legal rights.
I saw Gideon come out of the Bay Harbor pool room with a pint of wine in his hand. He made a telephone call at the street corner. In a while, this taxi picks him up and off he goes.
You call a cab, buddy? Yeah.
I went back to the pool room and saw it had been broken into. The front was off the cigarette machine and the money box was lying on the pool table.
I was the state prosecutor at Mr. Gideon's trial. The state prosecutor has the duty of representing the state of Florida, assembling the evidence and presenting the evidence to the jury. You have just heard the testimony of the state's principal witness. This witness testified that he saw Mr. Gideon in the Bay Harbor pool room. This witness's testimony was given under oath. It was simple, it was direct, and it was most damaging to Mr. Gideon.
As the presiding judge in this case, it was my duty to see that both sides, the state and the defendant, had an equal opportunity to present their evidence to the jury. It is my opinion that Mr. Gideon did a good job in presenting his evidence at this trial.
Well, I presented my case to the best ability I had. I questioned the witnesses, made a plea to the jury, and I don't think there's anybody can walk in the courtroom without being scared to death.
Have Have you gentlemen reached a verdict?
We have, Your Honor.
Would you hand it to the clerk, please? Mr. Clerk, would you read the verdict, please?
We, the jury, find the defendant Clarence E. Gideon guilty as charged. So say we all.
So say you all, gentlemen.
Yes, Your Honor.
Clerk, file the verdict.
Mail call, Clarence.
One day, the State Welfare Department wrote me to sign release papers on my children. I refused. I did not intend to let anyone take my children away from me, and I was going to fight it every way I knew how. I believed although I was a convict, I had a right to have children the same as anyone else. It was a good prison, as prisons go. I've seen enough of them in my life, and this wasn't bad. I was a trustee, we had a lot of privilege, and I tried to keep busy. But prison time passes slow. As the days went on, I improved my ability as an electrician in an electric shop. But I wasn't about to settle down for good, not if I could help it. Not for 5 years. October 30th, 1961, to the Supreme Court of the State of Florida. I, Clarence Earl Gideon, inform this court I am a pauper without funds or any possibility of obtaining financial aid. I beg this court to listen and act upon my plea.
Petition denied.
January 8, 1962, to the Supreme Court of the United States. Comes now the petitioner, Clarence Earl Gideon, a citizen of the United States of America, in proper person and appearing as his own counsel. Petitioner will attempt to show this court that a citizen cannot get a just and fair trial without the aid of counsel. It makes no difference how old I am, or what color I am, or what church I belong to, if any. The question is very simple. The question is, I did not get a fair trial. I requested the court to appoint me an attorney, and the court refused.
Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw...
On June 4th, 1962, the Supreme Court announced in its order of the day that it would hear Gideon's case. Among the justices who would weigh the arguments was one with a long-standing interest in the problems raised, the Honorable Hugo L. Black. 20 years before, in 1942, the court had considered a case almost identical to Gideon's, Betts against Brady. Smith Betts, like Gideon, had appealed his case to the Supreme Court. The majority opinion?
In most states, it has been the considered judgment that appointment of counsel is not a fundamental right essential to a fair trial.
But 3 members of the court dissented, among them Justice Black.
No man should be deprived of counsel merely because of his poverty.
Thus, the decision in 1942 in the case of Smith Betts. In state courts, a poor defendant was not entitled to a lawyer except under special circumstances. Gideon, in his petition 20 years later, mentioned no special circumstances. He said nothing about being mentally incompetent or illiterate, nothing about his case being legally complicated. But in June of 1962, the court voted to consider Gideon's case. And this meant that they would reconsider the older case, Betts against Brady. After 20 years, the Supreme Court might change its mind.
Dear Mr. Fortress, I have been informed by the clerk of the Supreme Court that you are appointed to represent me. Everything contained to my case is of the highest interest to me and everyone in prison. And we will certainly welcome all the information about it that is possible. Sincerely yours, Clarence Earl Gideon.
There was no question now that Clarence Gideon would have a lawyer represent him. Appointed as his counsel was a prominent Washington attorney, later to become himself an Associate Justice of the Supreme Court, the Honorable Abe Fortas.
I received a call from the clerk of the Supreme Court telling me that the court had designated me to act as counsel without fee for Clarence Gideon. At the time, I knew only that Gideon had been convicted of a felony in the Florida state courts, and that the issue involved was the right to counsel.
Opposing Mr. Fortas in the Supreme Court hearings was an Assistant Attorney General of Florida, later to join the law department at Emory University in Georgia, Mr. Bruce R. Jacob.
We argued in the United States Supreme Court that historically the Sixth Amendment right to counsel meant only that you had the right to have counsel at your own expense. It did not include the right to have counsel appointed for you at state expense. We pointed out further to the Supreme Court that throughout history the states have always had the power to enact or adopt their own rules of procedure in criminal trials, and we said that if they should require an absolute rule, if they should adopt an absolute rule requiring the appointment of counsel in all criminal cases, this would be intruding upon an area traditionally and historically reserved to the states.
The 14th Amendment itself specifically provides that no state shall deprive a person of life or liberty without due process of law. This means that no state may imprison a person unless he's had a fair trial. To have a fair trial, a person must be represented by counsel, whether he is rich or poor.
Under the Betts versus Brady rule, a defendant in a state criminal trial had to make a showing of special circumstances in order to be entitled to the appointment of counsel at state expense. In other words, he had to show either that he was illiterate or ignorant or in some other way unable to handle his own defense. Since Gideon had made no showing of special circumstances in his petition before the Florida Supreme Court, he was not entitled to relief.
The plain fact of the matter is that nobody can defend himself when he is on trial, accused by the state of having committed a serious criminal offense. As I later said to the Supreme Court upon argument of the case, I remembered that when Clarence Darrow, one of the great criminal lawyers of all time, was accused of crime, he immediately went out and hired a lawyer to defend him.
In our presentation before the Supreme Court, we indicated that should the court adopt an absolute rule requiring that counsel be appointed in every single criminal case in a state criminal trial, such a rule would logically have to apply in minor criminal cases as well as in felonies such as robbery and burglary. Furthermore, since the rich man can hire detectives, psychiatrists, and ballistics experts to assist him in preparing his defense in a criminal case, these same benefits should be made available to the poor man at state expense. These requirements would create enormous practical difficulties in the states.
But that cannot deter us, and it has not deterred us from doing justice in the individual case. And more than that, the time had certainly come when this basic principle of justice, that every man accused of serious crime is entitled to counsel, the time had come when that basic principle of justice had to be announced and established.
After hearing the arguments in the case, the members of the Supreme Court met in secret for a formal vote. How would you have voted? What would your decision have been? Why? On March 18, 1963, the decision was announced. Speaking for a unanimous court was Justice Black.
From the very beginning of our nation, we have laid great emphasis on fair trials in which every man stands equal before the law. This noble ideal cannot be realized if a poor man charged with crime has to face his accusers without assistance. The right of a man to have a lawyer may not be considered essential in some countries, but it is in ours.
August 5th, 1963. Just 2 years and 1 day after his first trial, Clarence Gideon was granted a new trial, this time with benefit of counsel. Attorney Fred Turner, in his pretrial investigation, had uncovered a surprise witness whose testimony cast grave doubts on the state's case against Gideon.
In Apalachicola the night before, and that he had returned home about daybreak, and that 2 of his friends had driven him back from Apalachicola, but they let
The jury's verdict?
Not guilty.
So say you all, gentlemen?
Yes, sir.
Ex-convict, wanderer, a former gambler, in prison slang, a 4-time loser. And yet this man was able to contribute in a major way to our understanding of the Bill of Rights. But what has changed since the Gideon decision? The Supreme Court of Florida applied the Gideon rule retroactively, granting new trials to hundreds of prisoners, releasing others outright. The results? 1 year after the Gideon decision, more than 1,200 inmates of Florida prisons had been freed. A study made 2 years later indicated that surprisingly few, only 13%, had been returned to prison with new convictions. The national average, 25%. But there were other problems raised during the Gideon hearings, which have since been dealt with in a series of historical Supreme Court decisions. A suspect is apprehended and arrested.
Okay, let's go.
At the police station, where he will be booked, he must now not only be informed of the charge against him, but of his right to remain silent and of his right to a lawyer. No longer may he be questioned by the police without legal advice. When brought before the criminal court for arraignment, he must again be informed of the charge and of his right to counsel. However, if the defendant cannot afford counsel, the judge may pick a lawyer who happens to be in the courtroom. The lawyer will not be paid for his services. He will not receive a shred of investigative or expert help. In an adjoining room, he will exchange a few hasty words with his new client. In many cases, the defendant may be advised to plead guilty. He may feel that he has no other choice. Such assignment of an unpaid lawyer can make a farce of the Bill of Rights. Everyone knows this: the judge, the district attorney, the assigned lawyer, and of course, the defendant himself.
We plead guilty, Your Honor.
It can happen, and it does happen, in some American communities. There are other possibilities. In some states, full-time public defenders, experienced trial lawyers paid by the state represent the indigent. In many communities, legal aid societies compensate private lawyers for their time and expenses. Many lawyers throughout the nation represent poor defendants purely out of a sense of public duty. The Gideon case, together with later Supreme Court decisions, marked a turning point for legal procedures in criminal cases. Throughout the nation, a lawyer must now be assigned a poor defendant as soon as possible after his arrest if he requests one. But the question of the quality of defense still persists. A poor defendant is often assigned a lawyer who takes little interest in his case. Some experts have charged that we have one law for the poor and another law for the rich. A defendant with money can afford to hire special investigators, ballistic experts, handwriting specialists, psychiatrists. What of the poor defendant?